Hello friends, welcome back to my channel. Continuing with the series Important Case Laws from the Law of Contract, today I have come up with the case Dunlop Pneumatic Tyre Company Limited versus Selfridge and Company. This case is one of the leading cases of the law of contracts, and the concept of privity of contract was reaffirmed in this case. So let's start with the facts of this case. The Dunlop Pneumatic Tyre Company Limited was a tyre manufacturer company. This company entered into a contract with a dealer company, that was Due and Company in instant case, whereby it was agreed between the Dunlop company and the Due company that the Due company, who was the trade purchaser, would purchase a quantity of tyres from the Dunlop company and would not resell the tyres at price less than the listed price. And it was further agreed that any reseller who wanted to buy them from the Due company had to agree not to sell the tyres purchased from the Due company at the lower price either. So the Dunlop company would sell certain quantity of tyres to the dealer, that is the Due and Company, and it was agreed between the parties, that is the Dunlop company and dealer company, that is the Due company, that the Due and Company would not resell the tyres at price lower than the recommended retail price. And it was further agreed that any retailer who would purchase the tyres from the Due and Company would not sell the tyres at price lower than the recommended retail price. Now, the dealer company, that is the Due and Company, sold the tyres to a retailer who was Selfridge. So it was agreed between the Due and Company and the Selfridge company that if the Selfridge company who had purchased the tyres from the Due company would sell the tyres at a price lower than the listed price, then the Selfridge company would pay damages. For the violation of the agreement. So the Selfridge, the retailer, the Selfridge company was also required to sell the tyres at the recommended retail price. The Selfridge company proceeded to sell the tyres below the price he had promised to sell them for. So the Selfridge company sold the tyres at a price lower than the recommended listed price. Now the Dunlop company came to know about this fact that the retailer Selfridge company is selling the tyres below the recommended listed price. So the Dunlop company brought an action against the Selfridge company for the violation of agreement, and the Dunlop company was successful before the trial court. That is, the trial court directed the retailer Selfridge company to pay damages to the Dunlop company. The Selfridge company now went in appeal, and the appellate court overturned the decision of the trial court. As against this decision, the Dunlop company has come up in further appeal. Selfridge company argued that since Dunlop company was not a party to the contract between the Due company and the Selfridge company, hence it was not part of the agreement between the dealer and the Selfridges. So the Selfridge company argued that the Dunlop company could not enforce the agreement that was signed between the Selfridge and the Due company. The issue that arose before the second appellate court was, is it lawful for the Dunlop company to sue Selfridge company even though no contractual relationship existed between them? The court held that the Dunlop company could not claim for damages in the instant case. The court found that only a party to a contract can claim upon a contract. The court held that only a party to the contract can enforce the contract. But in instant case, the Dunlop company was not a party to the contract that was entered into between the dealer, that is the Due and Company, and the retailer Selfridge company. So the court held that the Dunlop company was not part of the agreement, so it had no right to enforce the contract. The court further held that the Dunlop company had not given any consideration to the retailer company, that is the Selfridge company, and hence there was no binding contract between the Dunlop company and the retailer Selfridge company. The court further held that also the Dunlop company was not listed as an agent in the contract, or the Dunlop company was not mentioned as an agent in the contract that was entered into between the dealer Dew & Company and the retailer Selfridge company. Hence, the Dunlop company could therefore not be included as a valid third party who had the rights to claim on the contract between the Dew & Company and the retailer Selfridge company. Hence, by applying the principle of privity of contract, that is, a stranger to a contract cannot sue or cannot claim under the contract, the court in instant case also held that since Dunlop company was a stranger to the contract that was entered between the dealer and the retailer Selfridge company, hence the Dunlop company could not enforce the contract as it was a stranger to the contract that was entered into between the dealer Dew & Company and the retailer Selfridge company. Hence, the appellate court held that the Dunlop company was not entitled to enforce the contract and claim any damages from the retailer Selfridge company. So, this was all about the case Dunlop Pneumatic Tyre Company Limited versus Selfridge & Company. Thank you for listening, and if you like the content of my videos, please subscribe to my channel and do like and share the videos. Thank you.